Masters, if you can keep your masks on, please, when you're not addressing the court.
Right, okay.
Okay, thank you.
You like on? So I'll put it on, yeah?
Excellent. I think it's Ray and Ray.
Rear and rear.
Yes. Excellent. Thank you.
Just suffocated.
Rea is the...
Rear, yeah.
Rea, yeah.
Sometimes it reminds me, oh, in the court of the old so you called it,
Yeah.
in a matter of rear and rear.
Everyone's listening. No.
We're going to know it last, don't we, whatever way. I thought 67 as a rule, but it's not got live stream.
Oh, I didn't know that.
It is planned to be done, but we haven't got it yet. I wasted it for live stream.
Yeah, no,
I think that was probably a delusion. They said they want to put it on until everyone is in, because of all the chit chat that probably I was doing on the rest of the class. I remember me mask. Most people think I'm exempt because of my age. I never correct them.
how could they do that?
Easy, because I tell them.
There's something.
They go mask, I say yeah.
Yeah,
I'm
but
exempt.
it stops you from catching it though. So you don't want to go in.
No, it's not the point. It's protecting others, no. Although I know it is, but I still believe it's a two-way
Yeah,
thing.
it's a two-way, definitely. Yeah.
Yeah, that's probably a conversation I shouldn't have had and admitted to them. That's where you're wrong, it's our way. I can't do anything.
But it's recorded as well.
I know, but it's gone out live.
There's only one person watching.
Huh?
There's only one person watching it.
It's usually quite good. You might be able to practice.
Tell mine.
Hmm?
Tell mine.
We could really know.
fit?
Good exercise.
The lifts are out of action.
Are they?
Well, I couldn't get mine.
No, I just came up anyway. Yeah.
Stand, please. This is an appeal in the matter of Rita Rea.
Morning, my lord. I appear
Yes,
to
Mr.
be
Howard.
appellants, my learned friend Ward Price for the respondents,
Yeah.
who are all present with the exception of
Who are
Raymond
what?
Rea. They're all, the parties are all present,
Yes.
apart from Mr. Ramo Rea, who's misspelt in the title of the action. It's an M, not an N.
Right.
He has got long COVID.
Right.
Maybe watching on the live stream.
Yeah. Well, I can tell you, Mr. Howard, that we have obviously read the skeleton arguments, we've read the judge's judgment, we've read the Deputy Master's judgment, and we have read the transcript of the day's proceedings.
Thank you very much. Very helpful. Well, you'll therefore know that the mother formed the view that her 3 sons had abandoned her and therefore resolved to change her will, and the issue for the court was how she came to that view. It was pleaded, or the son's case, or the brother's case, was that there was misrepresentation, fraudulent calumny, and undue influence on the part of the respondent, their sister Rita. But the heart of the case, we say, was not put to her, certainly wasn't put by the brothers, although questions were put by the judge and by my learned friend for the then claimant. And the reason for that was not a matter of decision, as sometimes happens, particularly in family cases, which I will look at presently, but because of a mistake. There was no bias, no animus, except all those findings, no ill will, but this should not have happened. And the question, therefore, is what is to happen to the trial? And our submission, of course, is that made the trial unfair. There is no remedy for an unfair trial except to have another trial. And I propose to begin with a look at some of the authorities to see what principles can be extracted, and then move to the details of the particular case. The appellate process has refined the argument somewhat. You'll see that there was a broader challenge to many parts of the trial, and a whole schedule of things from day one through to the end. I
take it that you are still relying on all the points that were scheduled to
Yes.
Mr. Justice Adam Johnson's judgment.
Yes, but I'm focusing on the big mistake.
After Rita was recalled?
Exactly. Late in the afternoon of day one, exactly, where the judge read his note and thought the questions had been put.
Yes, and they'd had up to a point, but not by the brothers.
Not by the right people, exactly. That's exactly right.
So that's the main ground, is it?
That is.
Right.
We accept the conclusions on animus. There may have been some impatience and there may have been some case management points which other judges would have dealt with differently, but the core of the problem is this big mistake that happened about the case.
I just need to get this clear.
Yes.
One of the things that you mentioned in your skeleton argument is the examination in chief of Rita. Is that something that you complain about to us?
I shall be taking you through it because part of the finding of the judge on appeal was that remedied the problem. It was one of the 2 things that had provided the remedy, one being that and the other being the judge's own examination of the witness at the end. And those 2 put together, and our submission is that neither of those, nor both together.
No, I follow, but the mere fact that she was examined in chief is not the subject of complaint here. Is that right?
No, my lord. I mean, it's unusual, but it happened, and it's the way it was then done. It's old-fashioned.
I follow.
It's what used to happen
Now,
before
at the end of the
1998.
examination in chief, David asked for some time,
Yes,
and the judge said no.
yes,
Is that the subject of
yes.
It is.
That in our submission should have been. He should have been allowed time because, well, I'll come to it, but absolutely yes. So, but the focus is on Mr. Justice Adam Johnson's paragraph 103, which is in the full bundle at page 59, and it's the passage cited in the argument and in the grounds. I agree that the Deputy Master's mistake over who put certain questions to Rita during the early part of her evidence was unfortunate, but I do not think it rendered the trial process unfair. The process overall unfair, that is for at least two reasons, and then he gives the two reasons. And he develops, he quotes at some length from the examination in chief by Mr. Ward-Prowse, and doesn't quote at such length, but mentions and relies on the examination by the Deputy Master himself. And I propose to...
Just as to that, the reference to what had happened in chief is in the context of the first point, isn't it?
Yes.
So the remedying is in terms of what the master asked.
Well, no, my lord, my understanding of the judgment is that is for at least two reasons.
But the first reason is that the mistake was an understandable one.
Well, yes, I suppose so, but also the fact that Mr. Ward-Prowse is putting the defendant's case to her means that she did get to answer, she did get the case put to her, and therefore the court was not given no idea at all of what she would have to say.
I mean, I follow that might be a relevant point, but that isn't quite how Mr. Justice Adam Johnson is putting it, is he? He says, the first point is that the mistake was an understandable one, and then he deals with that point, and then at 106 he comes on to his second point.
Well, yes, but he does, my lord, at 105, so it seems to me...
Yes, I see, yes, okay.
was helping the defendants.
But I mean, he does say an understandable one because what Rita's counsel was
Yes,
doing was
exactly.
putting the defendant's case to her,
Yes.
which he then developed. So I think what you say is it may provide both an explanation or reason why it was an understandable mistake that the Deputy Master made,
Yeah.
but it doesn't remedy the unfairness of what had occurred and the denial of
Exactly.
the right to go over the same points in cross-examination, properly so called.
Exactly, my lord. Yes, yes, yes. I mean, you have it in a way. That's the whole argument. But I'm not going to sit down now because I'm going to take you through the authorities and the actual transcript, if I may.
And as I understand it, the reason that you say that you complain about the refusal of the adjournment for 30 minutes after examination in chief had concluded is that, as I understand it, there's a lot of new material come in during examination in chief,
Yes.
which a cross-examiner would want time to reflect on because it's not what normally happens, what in fact shouldn't have happened without the permission of the court.
Exactly.
You make the point about CPR 32.5, 3 and 4.
Exactly. I mean, and in every trial, it's always been that you were entitled to notice of what the witnesses called by the other side are going to say. And if you don't, you ask for an adjournment.
We don't have Rita's witness statement.
No.
Sorry, I'm going to call people by their first names. I
Yes.
hope everybody's happy with that. But
Yes.
we don't have Rita's witness statement
No.
in the bundle.
No, my lord, we don't.
We have the other ones.
Yes.
To what extent did examination in chief go beyond the contents of Rita's witness statement?
Well, we can see from the text of the transcript itself that my learned friend took his witness to or through various points that were made in the defendant's witness
Right.
statements, and spent several pages on that.
Yeah. I mean, is there any reason why we don't have Rita's witness statement in the bundle?
Well, it seemed to me, composing the index, that what the court needed was
Okay.
the transcript.
But I mean, as you quite rightly say, the pleaded case was misrepresentation, undue influence, fraudulent calumny, and so on. One might have expected the witness statement to cover the points that were in the pleading. Is that not what happened here?
My lord, no. Well, I mean, what we end up with is a very extensive examination, which really almost.
Well, I follow that.
Almost,
But my lord's question was, how far beyond the witness statement did it go? And all I'm suggesting is that if there is a pleaded allegation that somebody unduly influenced somebody else and or told them lies, one would have expected that to be covered in the witness statement. So it wasn't?
My lord, I don't think that. I mean, certainly certain aspects weren't. The exclusion of the friend, Mrs. Strawn, for example. I don't think that there was anything on the details of the sale of the flat and the debt owed to the Department of Work and Pensions. The text messages which referred to the word abandon, or used the word abandon, these were all, I think, not dealt with.
And there was
They
a
hadn't been
document.
pleaded either.
And there was a document that was introduced
And there's the document
in
that was
chief
introduced,
as well.
the April of 2016 note.
Yeah.
And well, sorry, the letter from the 1970s to the care of the President of Bangladesh, I think it was.
Yeah.
Which obviously didn't get that to the ex-husband. Well, can I start with some of the authorities and come back to the facts of a particular case?
I should perhaps also tell you we read Seraphim
Seraphim,
and National Coal Board.
Thank you. Well, National Coal Board, I'm certainly going to take you to passages in the National Coal Board. Seraphim is obviously very recent, highest authority, and very crisp and short. It's 9 paragraphs, state principles extracted from the authorities with great clarity, and it's extremely helpful. And we get out of that unfairness is not the same as bias. Judicial intervention at the evidence phase is particularly prone to result in unfairness. Preventing a party from putting his case but in cross-examination may result in unfairness, and the reasons for that, I'll take you to the judgment in Jones and the National Coal Board. Mistake or inadvertence as opposed to animus is not directly covered, but it is quite clearly covered in Jones, and my suspicion is that in principle it doesn't make any difference. Unfairness is an objective test, and if the ball is out and the line judge calls it in, it doesn't matter whether he's short-sighted or whether he's got a bet on the outcome. It's equally a wrong decision. And if I could start by looking at Jones, this is a case from the Chester Assizes. A miner had died down the mine at Wrexham, and looking at the head note on this is tab 1 of the authorities bundle, and using the internal numbering in the report, it's page 55, the first page, the head note, looking at the 3rd paragraph, at the trial of the action, the trial judge intervened, and it summarises how often he intervened and how often he actually stopped over the page altogether cross-examination on the issue of chocks, which was important. Chocks as opposed to the use of props, and the evidence was therefore incomplete on whether chocks was a viable alternative in the circumstances. And that was one reason why it had to go back for a retrial. Now, held that although the judge was actuated by the best of motives, so there we are, that's the answer to animus, his interventions taken together were excessive and ill-timed, with the result that no sufficient primary facts have been elicited to enable the appeal court to determine issues as to liability. Therefore, a new trial. If I could take you on to page 59, in the submissions of counsel, we have a galactic barge in this case. Mr. Edmund Davis, Queen's Counsel, submitted that the judge's conclusions on liability were right and inevitable, has a direct bearing on the validity of the ground of appeal that the plaintiff was denied a fair trial. Unless it can be said an injustice resulted, the court should not concede a new trial. That submission was rejected, and we can see that Mr. Gardner, you see, in response for the plaintiff, made a similar submission, hoping to avoid a retrial. We can see on the second page, page 60 down the bottom, only in the alternative a new trial is asked for. A new trial would involve hardship for the plaintiff, but hardship, undoubtedly, it would have caused a coal miner's widow in 1957. Now, in the judgment, on page 63, we get no doubt that the judge, intervening as he did, the top first full paragraph, was actuated by the best of motives, so that settles that. It was already in the head note. And then we get a magnificent purple passage on over the page on the subject of the adversarial system, and citations from Lord Justice Burkitt, among others. And the judge's part is to hearken the evidence, only asking himself questions of witnesses when it's necessary to clear up any points being overlooked or left obscure. And then on the next page, we get a passage which is quoted partially in Seraphin, and I've sidelined in black. I hope we've got the marking there. Actually, the passage really starts a little higher up. There is one matter at the top of the paragraph which we would specially mention. Mr. Gardner made particular complaint of the interference by the judge during cross-examination. So that's where we are particularly with this case, Seraphin obviously being a case that's rather broader. And he sets out the importance of uninterrupted cross-examination for a fair trial, and the very gist of it, unbroken sequence of question and answer, grave disadvantage if counsel is prevented from following a preconceived line of inquiry, which in his view most likely to elicit admissions from the witness or qualifications of the evidence given in chief. Excessive judicial interruption inevitably weakens the effectiveness in relation to both the aspects we've mentioned, but one and the same time gives the witness valuable time for thought before answering a difficult question, and diverts cross-examining counsel from the course he's intended to pursue, and is by no means easy to return. And just the last passage I draw to your attention, I've also marked on the final page of the report, page 67, which is the outcome, which is it has to be a retrial. There's one thing: everyone in the country is entitled to a fair trial, which he can put his case properly before the judge. No cause is lost until the judge has found it so, and he cannot find it without a fair trial, nor can we affirm it. That's another passage that's in fact quoted in Seraphin. The next case in the bundle is Michel, which is also quoted in Seraphin, and I'll just take you to a bit on the page 887 of the report. It's page 25 in the bundle, the bigger numbers, perhaps easier to find on the bottom of the page. 25. And it's paragraph 31. This is Lord Brown. The board would add, not only is the accused in such a case deprived of the opportunity of having his evidence considered by the jury in a way he was entitled, he is denied to the basic right underlying the adversarial system, whether by jury or jurats, this being Jersey jurats, that of having an impartial judge to see fair play in the conduct of the case against him. And then he goes on to refer to Jones. That, of course, is a criminal case. Now, I submit you can take from this that the important right here is for the litigant to put his case properly and effectively, and in his own way and without interruption, unless, of course, it is necessary. Now, this may be qualified when the party's in person, and this comes up especially in the family division, and there is some learning from the family division which may assist on whether the use of the other side's counsel, or alternatively the judge, as the source of the questioning can save the day when the party himself has been prevented, because of course in family cases it quite often happens that you've got parties in person whose cross-examination by whom would be oppressive because of the nature of the relationship, or one side at least is saying the nature of the relationship, and the nature of the allegations that are being put, things like rape and strangulation. And this comes up in tab 5 in S&P, where Mr. Justice Hayden was dealing with an appeal from Judge
Can you give a page number? I don't.
Page 67 of the bundle.
Yeah. One does sometimes find much the same thing in family cases about disputed wills, that there is a lot of heat and emotion, bitterness, jealousy.
Yes, and I mean in this case it's clear that at least one of the siblings is said to have had a particularly tense relationship with his sister. That's true, but we're nothing like of the scale that you get in
Well, it's certainly
in
not
a case
rape and
like
strangulation.
S&P. I mean, we haven't
agree.
rape, strangulation,
No.
and rape. And what happened here was in S&P was that the father and the mother are the parties, and the father, that the mother was making allegations against the father, including strangulation and rape, and the father was a serving police officer and did not have representation shortly before the trial. And as a result of his work, he was familiar with cross-examination, and he prepared a full-scale Crown Court cross-examination with challenges and previous inconsistent statements and the whole thing, which would have been extremely tough on the mother in the judge's opinion, and so the judge ruled that that was not going to happen and took it upon himself to ask the questions instead.
Yeah. So that was a case where the father was not permitted to cross-examine at all.
At all, exactly, that's right. And as a result, the judge took over and asked, put his case to him anyway, and it did it in such a way that, as you can see from the judgment of Mr. Justice Hayden, he really soft-pedalled it and underplayed it to the point where it just wasn't properly put at all. And the discussion that we get, first of all, it's quite instructive to see that on page 69, using the bundle numbering rather than the internal numbering of the report, we have, it starts with a long passage of the judge quoting himself in an earlier decision called Rita Rea. And he describes how very disturbing it was to have watched a lady being cross-examined by the man who was the direct cause of her unhappiness. And at paragraph 60, he gives vent to his opinion that it's a stain on the reputation of the family justice system that the judge cannot prevent a victim being cross-examined by an alleged perpetrator. It may not be the worst or most extreme example. So then to underscore that the process is inherently and profoundly unfair. Interesting word. I would go further. It's self-abusive. For my part, I'm simply not prepared to hear a case that way again. Cannot regard it as consistent with my judicial oath and responsibility to ensure fairness between the parties. Now, that's fairness that is used. You can have unfairness to the witness of exposing them to unnecessary suffering as in the process of the action. And of course, if she's a party, which she is in this particular case, you also have unfair trial and a breach of her Article 6 right, as gets considered in Rita Rea, the next case I'll come to. But we have a little bit more over the page, on page 71, at paragraph 11, where the judge refers to the, starting in the second sentence, the third line, the cross-examination of a complainant alleging rape requires particularly careful preparation, great sensitivity, rigorous forensic discipline. Ultimately, the complainant's evidence must be challenged effectively and the alleged perpetrator's case put fairly. This cannot be compromised. Nothing less will do. Family Court endeavours to be non-adversarial, adversarial, investigative, sui generis, and so on. None of this detracts from the fundamental premise that the party bringing the allegation has the burden of proving it to the civil standard of proof. And what went wrong in this case, you can see in paragraph 13, the questions, so far as they were put at all by the judge, were rendered superficial, overly simplified, and repeatedly phrased in a way so as to minimise their impact. Now, just a couple of phrases from over the page in paragraph 16. Whilst I'm extremely sympathetic to the situation Judge Scarrett found himself in, it must be emphasised, having decided to put the father's case, he was required to do so fully, properly and fairly. Fully, properly and fairly is a very convenient formula, and I'd ask you to mark it. And at paragraph 20 we get the result. Regrettably, it has to be a retrial. And he gave some suggestions about what the court could do, so long as a sticking plaster, so long as the legal aid situation remained, that representation in these situations was.
Can we just go on a little bit to paragraph 30? 30,
yes.
Where Mr. Justice Hayden quotes from Lord Dyson in Re K.
Yes.
And Lord Dyson says in paragraph 58 of his judgment, Judge said it wouldn't be appropriate for him to be the cross-examiner. He didn't say why. Maybe he thought it would be inevitable he'd be perceived to be descending into the arena. The use of the term cross-examination lends support to that idea, but questioning by a judge need not be conducted as if by a cross-examiner acting for one of the parties. And so he goes on.
Yes, that's right. My lord, I've got K actually in
we have,
tab
yes,
3.
indeed.
Yeah. And it's the next one I'm going to take you to.
Right. K was all about whether the court had power to require representation. And the court said no, it didn't, but there are other things that could be done.
Well, it was really all about whether the court had power to order the courts and tribunal service to pay for representation.
Exactly.
And the contending party was the Lord Chancellor's Department, or the Treasury, basically, saying no, it didn't.
Yeah.
And thereby overruling the learning that had developed originally with the President, Sir James Mumby, finding a way through the regulations, which unfortunately came to an end there. But just still in S&P, the judge orders a rehearing, transfers it to the High Court, and makes a few observations as a forensic lifebelt until the rescue craft arrives, is how he puts it in paragraph 34, and suggests that, and I just look at mark 1, 2, 3, and 8 and 10. We have a ground rules hearing. The judge should be the same judge who's going to be at the eventual trial. He's got to require questions to be reduced to writing, perhaps identify grounds of cross-examination under specific headings. This is at 8. Not feel constrained to put every question the lay party seeks to ask. And at 10, it's inherently dynamic, and therefore the judge will inevitably have to craft and hone questions responding to the answers given. It can never become formulaic. But this is investigative, and of course these are circumstances which don't apply in this case. This cross-examiner, in our case, has not given any reason to be barred. K deals with similar material a little earlier, obviously, otherwise it wouldn't have been quoted in S. And it's a very similar situation, but the argument was about representation, and then which threw up the question of whether proceedings without an independent advocate to cross-examine on behalf of the party putting the serious allegations, could satisfy the requirement for fairness under Article 6 of the Convention on Human Rights. And that's the discussion that is mentioned in S, and the conclusion really in the end is generally speaking, yes, it could be fair if the judge did it otherwise. The real passage I'd look at is at paragraph 54, which starts on page 45. We heard much argument as to whether questioning by the judge would be compatible with the Convention. For those of us who've been schooled in an adversarial system, questioning by a judge a key witness on controversial and centrally important issues may cause unease. And he refers to Roderick Wood, J. in H and L. He said it should not be regarded as impossible, but should only be done in exceptional circumstances. And then he's referred to what Sir James Mumby, the President, had said in Q, which was the case that essentially found there was a rule that could provide for payment of the services of counsel, and therefore was set aside. He was careful to say no more than that questioning by a judge where the issues are grave and forensically challenging may not be sufficient to ensure compliance with the Convention. He then has a snippet of Lord Bingham in a criminal case, a difficult tightrope for the trial judge to walk. Before concluding, really,
I thought it was the case that in
60,
some adherence to the Convention, in their procedure, the judge does ask the questions.
in some countries,
Yeah,
yes,
thought so.
yes, and in this country, as the passage from Lady Hale, which was cited by the Master of the Rolls earlier on in Re K, mentions in family cases, and Lady Hale says that it has happened a lot more in olden days in the family division. But these are circumstances where the situation is, well, in my submission is that it requires it to be exceptional circumstance for it to be necessary for the judge to do it. And then at paragraph 60, we get the Master of the Rolls giving his view on it, a simple, straightforward case, questioning by the judge likely to be the preferred option. The judge will know what the unrepresented party's case is. It may be helpful to ask him or her to prepare written questions. These are similar suggestions that are echoed by Mr. Justice Hayden. And I understand from my learned friend of the current practice under the Family Court rules. Sometimes unexpected answers may be given. These may require the judge to ask the unrepresented party to comment and suggest supplementary. And so it could be fair, but that's not to say that there couldn't be an extreme case in paragraph 62 where it might not comply with the requirement for fairness. So, of course,
just going back to S and P.
Yes.
At page 77, you stressed the point made in 11, little Roman 11, right at the foot of the page, where Mr. Justice Hayden says it's always to be borne in mind the overarching framework of the Children Act proceedings. The central philosophy is investigative, even though fact-finding hearings of the nature contemplated here have a highly adversarial complexion to them. The same principle applies. Thus, it may be perfectly possible, without compromising fairness to either side, for the judge to conduct questioning in an open and less adversarial style than that deployed in a conventional cross-examination undertaken by a party's advocate. Is this point about the central philosophy in Children Act cases being investigative, where is that picked up in Re K? Is that picked up somewhere in Re K? You mentioned there was an earlier passage from Lady Hale.
Oh, Lady Hale, yes, that had been 25, I think it was. No. It was in the passage quoted from K in S&P. Sorry, paragraph 58. Yes, page 46. This is implicit in what Baroness Hale said in Re W.
I see.
And what she had said was quoted.
Is that paragraph 28 a quote from her in Re W? He says paragraph 28 provides. Is that a paragraph from the practice direction, child arrangement, contact orders, or is that a quote from?
I think that's a quote from the practice direction.
No, I think Lady Hale's quotation is in paragraph 57.
It just so happens it's
paragraph 28 of the judgment. Lady Hale said.
I said
sorry,
yes,
that's the quotation.
Right there in front of me.
they're both paragraphs 28.
Yeah, and she says the important thing is that questions which challenge the child's account are fairly put to the child, so she can answer them, not that counsel should be able to question her directly.
Yes, thank you.
Yeah.
Thank you very much.
Yeah.
So there's a type of litigation, but this, of course, must remember, this was adversarial, normal civil litigation, and there was no decision made about any bar, nor any grounds for any such decision to be made. It was just an accident by mistake. And the fair thing, therefore, wasn't to start straying into these unusual procedures. I'm looking for the test of fairness, my lord. Which is maybe it's just an ordinary word that the court has to interpret each time, but rather a protean concept. But I did bring along a couple of remarks. Lord Justice Patton in Gruby, which is at tab 6, starts at page 79. Page 94 is where this is a boundary dispute, where the judge had got, it would appear rather cross with the litigant who hadn't actually got any evidence about what the original boundary was in the first place. But paragraph 46 just gives us some words which may assist. I have reached the conclusion there was still a fair trial and a proper judicial determination of the main issues. The allegation of unfairness requires one to look carefully at what were the real issues in the case and how the judge's conduct impacted upon them. And we have a little from the then Chancellor of the High Court, now Master of the Rolls, Geoffrey Voss, at pages 97 to 98. In paragraph 61, he quotes Jonathan Parker in Kofi Adu, which is a case that's quoted at length in Serafin. The risk of interventions. The judge's descent into the arena may so hamper his ability properly to evaluate and weigh the evidence as to impair his judgment, and for that reason render the trial unfair. And at 64, Voss's own words, the judge's conduct did not in this case have the effect of preventing the defendants from fully and properly presenting their evidence, nor did it impair his decision making. And lastly, while we've got the authorities bundle open, I just mentioned G in tab 4, which is another case involving Lady Justice Black. She was also in Re K. At paragraph 38.
Page?
The 61.
61.
61, paragraph 38. Possibly a bit unhelpful, I don't know. As I said, the fairness of a hearing cannot be assessed mathematically or scientifically, nor is it dependent on a comparison between the way in which the judges have treated the two sides.
Yeah.
So, moving now to the what actually happened in our case. I propose if I may to look at first of all what the defendant's case was, which is the pleadings and their 3 witness statements. Shows all we had. What was the things to look out for? I would take this in order through the transcript. So we will get Mr. Ward Prowse first, then we'll get the cross-examination by the defendants, and then we get the judge's examination. But the logical order is what was their case, what was it that they got to put and didn't get to put, and what was supplied out of those wants, either by counsel's input or the judge's final examination. And in our submission, it's not enough. I'm very asking the court to remain firmly in mind of what Lord Justice Denning had to say in Jones in particular. It is not enough simply that an allegation was put in a perhaps rather faint-hearted way. It must be, and the words I rely on again, fully, properly and fairly. Now, his case, first of all, is pleaded in the defence, which is at the back of the core bundle, last pages of the core bundle, 144 and 145 are the particulars. And we can see that, in fact, paragraph 11 is actually alleging testamentary capacity, but the point pleaded in and relied on there is inaccurate declaration of paragraph 11 of the will. And paragraph 11 of the will, which is just on into the supplementary bundle, is the statement, I declare my sons do not help with my care, and there's been numerous calls from help from me, and they are not engaging with any help or assistance. They've not taken care of me. My daughter Rita Rea has been my sole carer for many years. That's the point of that plea. Although it comes under testamentary capacity, it's clearly a misrepresentation, or relevant to the case on misrepresentation or fraudulent calumny. At 12, we've got inability to understand or speak English, but at 13, we've got undue influence. That's by Rita using her position to exert undue influence and put illegitimate pressure. And then at 14, we've got misrepresentation and fraudulent calumny, and particular mentioned in the 3rd to 4th line, also the willingness of the defendants to assist with the care of the deceased is something that is misrepresented. And the defendants contend the claimant's misrepresentations were made knowing them to be false, calculated to poison the mind. Well, it doesn't matter whether they're poisoning the mind, as long as they're false and have the effect. Now, that's obviously a difficult case to prove, because it's something that's never going to be, or not necessarily, happening in front of anybody, and witnesses such as the doctor or the solicitor are not going to have anything to say about that at all. And in fact, it can be misleading to have them there and perhaps divert attention. And it's unfortunate, my lord will have seen that the problem, the reason why the brothers were unrepresented was because they were dissatisfied with their solicitors, who insisted on running capacity when they actually, as David Rea explained on the final day in his closing submissions to the judge, we haven't got a transcript, but we've seen it in the judgment and in the skeleton argument, he explained that they were not relying on that, but they were relying on misrepresentation and fraudulent calumny. And so that's their case. My sons do not help with my care, really, is not true. That's what's pleaded, and willingness to, the extent of their willingness to care. Now, the next source of material that we have is the defendant's witness statements themselves.
So is the corollary of the point you made that the doctor or the solicitor wouldn't have anything to say about the case on particularly fraudulent calumny, that the evidence or the cross-examination of Rita was critical to that.
Yes, I mean she's got to be the only person really who's going to have been present at conversations. Although there's some evidence which I'm going to come to in the brothers' witness statements which assists them slightly, but the core of it is the nature of that allegation is you, Rita, represented a state of affairs to our mother which was not true.
And what about the other witnesses that were there? One of the two, the carer who was witness summoned.
They were called and they weren't helpful. It's my lord, you're right. They were summoned. Yes, the cousin who resigned from or disclaimed being an executor. And the carer.
We don't have the transcripts of
No,
that evidence.
No, that was on the second day.
Yeah.
No, except but we do have what we have in their witness statements. Can I just take my lord to those? We have first of all Ramo, who starts in the supplementary bundle on page 9, and the numbers in the supplementary bundle have slightly vanished under the handwritten numbers, but they're just visible there. It starts on page 9. Going to page 15, we have at paragraph 45, Dawn Strawn, referred to as having witnessed the claimant blocking access to my mother. She confirms the claimant used to say various things when Mrs. Strawn was trying to talk to my mother. She also saw the claimant on a number of occasions stand in front of my mother to stop communication with my mother or hold my mother in the house or the car until they had gone so they could not speak with her. Now that's quite specific events that could be put. We also have paragraph 50, Ivy Strawn, who is the mother of Dawn and the oldest friend of Anna, the testatrix, confirming this is again reported speech, but it's something that could have been put, that the claimant stopped her from being able to talk to my mother on a number of occasions, particularly in her later years. We also have the allegation on the next page, paragraph 56. This is Angela Contucci, who was called and did not come up to proof, saying that she witnessed the claimant really bad-mouthing David, the third defendant, in front of our mum. So there's another specific point that could be put. In the evidence of Nino, which begins on page 19.
Well, sorry, but Mrs. Contucci was called under a witness summons.
Yes.
And you didn't give that evidence.
Not that particular thing, no.
So the fact that that wasn't put to Rita
that would have been another source for it, but the fact is that it wasn't put to Rita when at the proper time it certainly should have been. The fact that subsequently Angela Contucci comes along and doesn't come up to proof doesn't help on the fact that this did not get put to Rita, and clearly could have been a specific instance. Nino is on page 19, paragraph 23 of Nino.
So I find it difficult to see these paragraph numbers.
They're very small. They're
what's the handwritten number?
The handwritten number is 304. The big flat handwritten number 304. At the very top of that page is the paragraph. Furthermore, when the first defendant lived in America, that's Ramo. Nino speaking about Ramo, between 2012 and 15, he tried to speak with our mother, but the defendant blocked his calls and his letters, so he ended up sending letters for me to personally take by hand. So blocking Remo's calls and letters. These are features of the witness statement bearing particularly on the allegation of it being misrepresented to mother that the boys didn't care about her. Paragraph 36 is on page, using the handwritten, page 6. Where we have text messages, and these are set out and were put into an exhibit. And you can see down under B, as well as some fairly aggressive stuff in A and rude, we come on under B at little Roman 3, abandon, emphasis added. He ain't going to help. At 4, your abandon, emphasis added. And 5, fifth middle line, abandon, emphasis added. And he then explains why he's added the emphasis in paragraph 37, because this is the word used by my mother. And my lord will have seen from the judgment of the trial judge that that word appeared in the solicitor's notes, which were signed by the mother. It was an absolutely central word. And the suggestion here is that this is a word that did not come from Anna, the testatrix, but actually came from Rita. That's the point about that evidence. And then at paragraph 39 over the page...
Sorry, can you just give the cross-reference to, you said that we could see from the, which judgment?
The first instance judgment.
Yeah, so just give us the
abandon
cross-reference.
Is in the core bundle, page 128, paragraph 25. The instructions at that stage, he's in fact, previous page, paragraph 24, where dealing with Mrs. Sukul, the solicitor's file, which was in evidence. And at the very bottom page, there's an extract from that file, a note. And you'll see at the last sentence, the other children have abandoned her. There's that word. And over the page, the word again appears in the next passage quoted.
Sorry, I'm struggling to find this page. You said
Sorry,
page
127 of core bundle.
127, of course, sorry.
127
Yep.
of core bundle is the very, very bottom. Almost,
Yep.
well, the second last word on the page is abandoned.
Yep.
And it's in a note on the solicitor's file.
Sorry, yeah.
And these, then over the page, we get another note from the solicitor's file, again using the word. And then we get at paragraph 26, Mrs. Rea signed each page of the notes. Mrs. Sukul was asked who used the term abandoned, and her evidence that this was the word Mrs. Rea used. And although it doesn't actually appear in the passage in the text of the will itself, it's clearly of a piece with it and central to the allegation.
So the allegation is that, assuming Mrs. Rea used the word in front of the solicitor and the solicitor's recorded that, but the allegation is what? That
was she believed
Rita effectively had put the word into her mind so that she then used it.
The allegation is that Rita has put that in her mind, exactly, and that's therefore fraudulent calumny. And this is the nature of fraudulent calumny. This is the difficulty. The solicitor's only going to say, well, she certainly had a very strong opinion about it when she was in front of me, and she was quite clearly of full capacity. And that, of course, is the fruit of a successful fraudulent calumny. And difficult to attack at trial.
Just hold on a moment, because like you at some point, and no doubt you will, just to take us to the bits of the cross-examination which reflect the points you've been making. I mean, you've told us that that the brothers did not abandon their mother, and that I think was put by David, page 77 and following of the supplementary bundle, when he's asking Rita about the rota that he's talking about, and that's all put to her. And you have made the point that it's alleged that Remo was banned, and that's put at page 86 between D and E, and going on further down the page. So some of this was put.
Yes, that's right.
What about the use of the word abandoned? Was that something that was put?
Well, no. The nearest we get is we get to the text messages.
Yeah.
In the judge's examination, and he doesn't actually put the abandoned bit. He just puts they're rather rude.
Right. Where do we find that?
153.
153.
Well, in fact, it starts at the bottom of 152. We've seen some text, which said this is the judge asking the questions, which are said to be from you, which are rather rude, if I may say so. Not sure if it's David or Nino. It might be David. When you're calling him some names, yes. Can you just tell me why you wrote those texts? If you want to take to the pages, can you remember enough about them? We get a long answer. What we don't get is the suggestion being put, which is absolutely in the witness statement of, I think it's Nino, that what those texts show is that she uses the word abandon. Yeah, that's exactly. In fact, that's what I was on, which is Nino on page 19, page 30. Paragraph 23, yes, page 304. Then we have in the same page, next page, paragraph 13. Sorry, yes, all those messages about abandonment on 306. And then over the page on 307, at paragraph 39, there's a handwritten note by the claimant which Nino exhibited, dated 19th of April 2016. So that's between the making of the will and the death of the testatrix, which outlined what she would do with the property once she inherited it.
Sorry, where are you? 307?
307, top of the page, paragraph 39.
39.
The witness statement of
you.
Nino. This is part of the case that didn't get put to the witness. I'm just taking out all of that case. Some of it was put and some of it wasn't. Is what happened. David, just to complete the picture, is on page, starts on page 406 handwritten, and at paragraph 43 on page 413 handwritten is again, he is saying that she is the source, paragraph 43, she is the source of the word abandoned. He doesn't have a particular thing to report, unlike the text messages in Nino's witness statement. But he does say that he is making the allegation that she's the source of the word and the idea. And at paragraph 46, we have a passage which crops up immediately that the examination of the witness begins. One of the main reasons, he says in paragraph 46, for believing that the claimant poisoned the mind. I think this is because about 3 or 4 years before 2015, myself and the claimant went to see the solicitor who made the 86th will. To my surprise, she remembered Mum like it was yesterday and confirmed the will was still valid. Myself and the claimant spoke to Mum several times over a number of years about the 86th will, mainly about the fact that the first defendant, that's Ramo, was the executor, but he'd been in America for a number of years. However, every time Mum would say she wanted to leave it alone and she was happy with it as it was, the claimant would get angry because she hated Ramo. And then the last little feature is on the next page, 414, in the final subparagraph 52C. My mother's mind was poisoned by the claimant against me and my brothers. She restricted our access to the mother in her later years, i.e. by changing the locks. And then a general allegation lied about our actions and intentions. Now, what we get out of that is we've got blocking access to Mrs. Strawn, the oldest friend, with specific instances of standing in the way and so forth. Bad-mouthing David to Angela Contucci. Blocking Remo's letters from America and calls. Text messages using the word abandon, and a general allegation that abandon comes from Rita. The note of April 2016 about what she was going to do with the house. A visit to the previous solicitor by Rita and David about the previous will, and series of conversations over the years, and she always used to get cross when Mother said, I'm not going to change it.
I'm a bit lost with the significance of the note of April 2016. That's
well,
after
it indicates
that's
that
after the 2015 will.
She knew the contents of the will.
So, what does that show? The will had been made by then.
My lord, yes. I'm sorry. I think I had it in mind that there was a suggestion that she didn't. She denied knowing what was in the will. But
so that would go to credit generally, not to the specific allegation.
Not to the specific allegation. That's right. The visit to the previous solicitor, the changing the locks, and the general lying. So those are all bits of case which are clearly in the witness statements. Now, the question is, how did that go? Were they fully, properly and fairly put? Well, Rita's examination in chief, my lord, begins at 46 in supplementary bundle. And, well, 47 is now I have some additional questions for you, and 25 pages later he sits down. What is said in the judgment is that this is Mr. Ward-Prowse seeking to assist the defendants by making sure the key elements of their case have been put to Rita as they should be. But in my submission, it's premature to do that before anyone's cross-examined on behalf of the defendants. It's not actually his place. It's deeply problematic, the idea that counsel representing somebody else should be discharging that duty of testing the evidence, his own evidence, in an adverse fashion. And all it really does is in fact provide thinking time and advance opportunity to answer questions in a soft and easy way.
Presumably, if I think you make the point that what should have happened is that counsel for the claimant would have asked for the permission of the court under CBR 35 to ask those questions.
Yes.
And because that permission is only exceptionally given, see subparagraph 4, you would have at least had to, there would have been a debate about what was the purpose.
Well, yeah.
And so the whole thing would have been ventilated, but it wasn't.
That's what should have happened, yes.
So the question of why are these questions being put by counsel for the claimant in chief would be out in the open for everybody to understand if it had been done the way the rules require it to be done.
Yes, I mean, I apprehend that my learned friend will say that the case came to him not terribly well prepared. He was instructed under direct access. This is not unusual.
Yeah, I'm not making criticism. I'm just simply looking at the question of if the rules had been followed. The question of why these questions were being asked in chief would have been ventilated.
Yes, it would.
And so everybody would have understood the purpose.
It would, yeah.
But that process wasn't gone through.
It was not. No, and we can see it just rolled on. I have a few questions, and 25 pages later, the whole case has been explored very compendiously, but not in obviously in the sort of hostile and adversarial way that the defendants were entitled to. It starts. The leading questions actually start at 55. Where he's actually at the top of 55. Now I'm going to ask some questions of you now to deal with the concerns and allegations your brothers raise in their defence, counterclaim and statement. And I'm going to go around headings. So here we are. To begin with, we have the question of use of English. Well, that's not really the fraudulent calumny point. At 56 and 7, we get the old letter to the husband addressed to Bangladesh. At 59, at the bottom, H, 59H, we get the next heading. The next allegation is you prevented contact between your mother and her sons, your brothers, and third parties. Now, the simple question is, have you ever knowingly prevented your mother from having contact with her 3 sons? Answer, I have never ever prevented or blocked. This is a very soft ball to have bowled at with when it goes to the heart of the allegation against you. At 60, on this page, we're into Angela Contucci at the bottom of the page, and then at the bottom of the next page, Mrs. Strawn, and the reference to Mrs. Strawn, and it turns out to be accepted that Anna lost touch with her friend Mrs. Strawn, and there's a reason why she stopped, it says at the bottom of page 61. And it's this is, I think, almost certainly a new case, because Dawn Strawn had got violent and attacked Rita. We get all on page 23, and to the top of page 24. That results in Mrs. Strawn stopping coming round. At 67, well, the bottom of 64 is where the passage begins, which the trial judge noted very fully in his notes, and that he later reads out, and it runs all the way through to about halfway down 68, and it's a good note when compared with the transcript. And at 68, we begin the question of making the will.
Oh, we got the reference to the abandon, use of the word abandon on 67.
Sorry, 67 is on the. That's right. 67.
That's the text messages, because Rita is invited to look at a statement, page 306, which you've shown us,
That's
and
right.
that allegation is put to her.
Yes. The word being abandoned.
Yeah.
She used to say that my father had abandoned us. So her answer is obtained from there. It's suggested that your mother would have never used the word. I did not ever know.
And
So,
then
of our-
68 is the misrepresentation stroke fraudulent calumny, but no doubt you will say that that was, again, very softly put.
Yes. Yes. Exactly. General line. Exactly. I've even put softly put in fact. So, in my submission, there is no way that that really amounts to putting the defendant's case fully, fairly, and properly as required. Now, David's cross-examination starts at page 74. First of all, he asks for the short adjournment of 30 minutes, which is not allowed. That was harsh. But we then get him cross-examining at the top of page 74, and in my submission, for all the judges,
Can you just say, you say it's harsh, you say it was wrong?
Sorry, thank you.
well, yes,
The 30-minute the refusal of the 30-minute adjournment. I understood you to say it's not just harsh; it was wrong.
well, I do say that, right? Well, yes, and
But just to
it's
be
not
clear,
my ground of appeal, but
Well, it isn't a ground for
Well, no.
the ground very much relates to it. You know, it's in amongst it.
But well, I mean, the grounds of appeal focus principally on what happened after Rita was recalled.
It does, yes.
That's the particular ground. If we look at page 14 of the court bundle, you say Deputy Master prevented cross-examination, did this by stopping cross-examination, which he said would be repeating matters.
Yeah. Exactly.
So, I mean, there isn't a specific complaint about the refusal of the 30 minutes.
But it's part of the story. It's also part of the way he effectively stops it, because the first time ever advocate is going to have his nerve shaken by these interventions, every one of them, and it's all part of the scene that you have to consider. So he refuses an adjournment, but then David Rea, his examination, despite the judge's comment somewhere later on, was actually quite organised. He starts at page 74 with, he's come to see her at Springfield where she was in hospital. 75 gets onto the flat sale. At 77 we've got the rota. We get quite a lot about how attentive they were or weren't. At 84 to 5 we get onto Ramo and when he was living there and how the relationship was with him and the non-molestation order. At 87 we get the allegation about banning a few people, including Ivy Strawn. At 88 he gets the new attack, which is the new explanation, which has already been brought out in chief about the attack on attack on Rita by Dawn. At 89 we get command of English, which is not really material, and then that takes us up to the short adjournment on page 101. So he has not at that point got to the text messages importing the word abandon, the changing the locks, blocking Remo letters, or general bad mouthing. And then we have doctor and solicitor, and she doesn't come back until page 142. And at this point, it all does. This is the core of my ground line. And it's a very rapid intervention that happens. Now, it's at this point, it's mid to late afternoon on day one. We know that after not many pages, we know that a short adjournment will get into 4:10, so probably 3:30 or later. This is the only witness remaining in the claimant's case, and it's a 5-day trial, so there is no time pressure. At 142, David Rea begins with the visit to the previous solicitor, which my lords will remember he's dealt with in a paragraph in his witness statement, which goes into subsequent conversations about the 1985 will and the mother's saying she doesn't want to change it and Rita getting annoyed because she doesn't like Raymond. And he begins on this, and very quickly, at the top of page 143, we get the judge intervening. How does that help? How does that have any... what's an issue in this case? And so Mr. Ray says yes. And it results, can we stick to the point, please? And he then confers with his brothers and tries again. When you found out during the making of the new will, when you found out it was going to be gifted to the house, did you question mother at all? We get down a few exchanges to was a copy ever sent to you, and the Deputy Master intervenes. It wouldn't have been sent to her, it would have been sent to the mother, and then all this was gone over and questions were asked earlier today, and we get the full intervention. And this results, rather understandably, in Mr. Ray at letter D on page 144. I'd like a 30-minute break. I don't feel well at the moment, to be honest. And this gets the answer. No 30-minute break. We're going to sit and hear the matter till the end of the day. I really wonder whether you have any further questions that you wish to put to this witness. We do, Your Honour. And then another brother tries, can we have a 10-minute break? Why? And my lord, you can see it's all there in black and white. It ends with, I am not, at the top of the next page, I am not going to have recapping questions. You will have until 4:10 p.m. to finalise what questions you're going to put, and I will not have the court go round and round in circles on old ground. Any matters we've covered before we will not be covering again. This is pretty strong.
There is a slight contrast. If you go back to page 100, before the question of the solicitor and the doctor attending has been raised,
Yes.
Master says, well, it's 1:10, I propose to adjourn, blah, blah, blah. And then he says, now, Mr. Rea, I think we should complete this witness evidence by the time the court rises today, which is about 4:15. Will you be able to complete? You will have 2 hours to put your questions. And at this stage, presumably, this is referring to the cross-examination of Rita. Or is it not? Is it referring to the totality of the witness evidence or just Rita?
Well, I don't know. Actually, I wasn't there. I've only,
No.
I know as much as you do.
But I think it must be, as my lord has indicated, that at this stage they had in mind it would be 2 hours to finish Rita, because it's what then causes Mr. Ward-Prowse to intervene at the top of page 101 to say, I'm very sorry, the doctor and the solicitor are attending at 2 o'clock.
Of course, yes.
So I think my lord is right, isn't he? That at this stage, at least that exchange was on the basis it would take 2 hours to complete Rita.
Yeah. Well, my lord, I'm very grateful for that. Thank you. I hadn't noticed it, but yes, it does show quite a change of heart in page 144 and 145. So. And this all kicked off in this passage about the on the topic that is covered in the paragraph in David Rea's witness statement, which dealt with previous conversations about the will and mother saying she didn't want to change it, and Rita having an angry reaction. So this is a critical topic, and bearing in mind the limits of what they've got to work with, trying to prove fraudulent calumny, i.e. a fraud perpetrated on somebody who, of course, isn't around to be asked, is central. Now, he gets the 10-minute break and comes back and starts again on, well, what about making Angela the second executor? So he's still trying to get at the changes that are wrought by the making of the new will. And we get only from letter D and a half to F before the judge is in again. Where does this go exactly? And hostile exchanges. We get eventually back to a question halfway down the next page where Mr. Rea has gets another question about changing the locks. At E, Rita stated. I'm sorry, no, this is. Well, we get the witness A. We get one answer, not true, at just above letter F on page 146 on changing the locks. And she changed the locks before my mother died.
Well, hang on, you need to go further up the page, just between B
Does
and
this
C.
go to your mother's?
Sorry, you need to go to between B and C, I think.
Oh, sorry. Oh, yes. Did you change the locks to the house? I'm sorry. Yes, I did. I'm sorry. Yes, the only time I changed the locks was after my son passed away, and then we get in discussion with the judge. How is this going to help your case? And he then explains what I was trying to get to is she said we could go to the house anytime she wanted, but she changed the locks so we couldn't get in. Not true. And she changed before my mother died, which obviously is important to exclusion. And the master, does this go to capacity? Which obviously he didn't know wasn't going to be an issue, but it's certainly not the issue that locks would go to. No, but it shows, or is it just throwing mud about? He keeps trying. The page, yes, but Rita changed the locks way before the mother died, and eventually the judge does allow it halfway down the page, effectively takes it over. After you change the locks, answer yes. Did you change the locks at any previous time? No. Right, that's the answer to your question. Okay, it seems you're lying. No. Right, that is put. And it's really not very surprising that we get less than a page later to letter E on 148, and Mr. Rea has had enough and says, thank you for your help. We do not have any more questions for Rita at this stage. Still, there's been no putting of the text messages in which the word abandon has been used by Rita. Still, there's been no mention of the 2016 note. The changing of the locks matter has come under heavy fire and not been. He's not had a chance to fairly simply put the questions to the witness at all. It's been the subject of the witness. The witness's input down that page is about 2 or 3 lines out of the whole page. And the rest is all judge against advocate. And the way the changing of the locks came out in the judgment, just to give you the reference, in Core Bundle 83, paragraph 20, is effectively the judge made no clear finding about it at all. It says it happened sometime in late 2015 or 2016. And so if it was a point of value, it's certainly not ended up in the judgment being put. Now, we submit that this is all a bona fide mistake, but it doesn't make any difference. There's no good reason for the interruption of the cross-examination, obviously, because none was advanced. It wasn't a matter of decision.
Well, I think you've got to look at some of the other things that the Master did. If you go back to 147, letter F, this is Mr. David Rea. I put it to you, you coerced him, and he asked the Deputy Master, can I do that? The Master says, yes. And then the Master says, well, if you're putting your case that your mother's will was overborne, then you can put that, that's your case. Mr. Rea replies, you took the words out of my mouth. Did you understand the question? And then the Master puts the question, did you make your mother write the will she didn't want? And there's a little interchange about that. That leads to Mr. David Rea saying, we don't have any more questions. The Master then says, you're entitled to put your case, bound to put your case. And then he says, so I'm going to ask a few questions which will help you do that. G, and arising out of my questions, you can come back if you want. Then the judge puts some questions to Rita. They include undue influence, page 153, letter E,
Yes.
down to H. They include giving a false picture, see 154B. Any questions are about our finances. Then we go on to 119. Mr. David Rea says, can we ask a couple of questions from what you said? And the Master says yes, arising out of the answers your sister gave to my questions. And there's a bit more cross-examination. 160, letter C. After some more questions from the Master, he says, I've asked the questions I think you were probably aiming at, but if there were any I were missed, please carry on. And then I think that's...
Well, yes, my lord. That's
And then at
true.
161, letter H, Mr. Rea says, I think we're done with the questions. Thank you very much for your help.
Yes. Well, that's all true, of course. But in the overall scheme of things, the witness has not been questioned by the defendants about these matters in an uninterrupted way, and the Master is doing what he can to allow the defendant's opportunity, but by that point he has completely taken over the entire ascendancy of how this is to be done. So rather than an afternoon of cross-examination as contemplated, we've got a very attenuated thing as a result of this very strong interventions which just shut it down. And so doing things that look quite good on the transcript, it's really too late by that moment. So although the judge's examination is quite crisply done, he's dealt with the word, he's mentioned the text messages, but without actually pointing out that they include the word abandon 3 times, as highlighted in the witness statement. He's he's put it very softly. In my submission, what's really happened is that it's just not fully, fairly, and properly put their case, and by that point, it's really too late, even for.
Well, that's your real point, isn't it? It's too late to repair the damage.
Yeah.
I mean, this is not a case, as in S&P, where the judge has ruled Mr. Rea will not be allowed to cross-examine, therefore I must take over the role of cross-examiner.
Yeah.
But you say that the judge, in fact, took over, at least in part, the role of cross-examiner, didn't fulfil that role in a way that a cross-examiner would, and by the time he came to offer Mr. David Rea the opportunity to ask further questions, which he did 2 or 3 times, as we've seen, the damage had been done.
Yeah.
That's really
it. Yes,
Yeah.
and what it is. So all the things that Lord Justice Denning refers to as the right of an informed cross-examiner representing a litigant, legitimate stratagems, preconceived lines, awkward questions, and unbroken secrets. That's all just completely been removed. And the result is that, for all the reasons that I've submitted, once the evidence gathering phase of the trial has been spoilt in that way, you can't ever.
But I mean,
source
I
that
think
together.
the judge, would you accept the judge has a bit more latitude where the party is a litigant in person,
Absolutely.
without familiarity, unlike the policeman in S&P.
Oh yes. Yes.
The judge must be allowed to help formulate the questions.
Yes, indeed, and it may be that quite a lot of what, I'm sure it was all motivated by the the best interests of wanting to see fair play, and no judge is going to sit wanting to have an unfair trial as the outcome. Of course, that's not his purpose at all. But unfortunately, that's what happened. So, I don't know if I can help you further.
I have no further questions. No, thank you very much, Mr. Howard. Yes, Mr. Ward-Prowse.
Yes, my lords, I'm very grateful, and you have read my skeleton argument.
Yes, certainly.
Can I firstly take you to the transcript of the hearing, and really we start at supplemental bundle at page 44.
Page
44.
44.
This is, I'm so sorry, at the top of page 45, where at A, Mr. Rea says to the court, this is the first time we've done this. We've not been in court before this sort of situation, and we'd like your help when you can help us, if you don't mind, Your Honour. And the learned master says, of course, as I said to you at the hearing last week, I will do my best to assist wherever I can properly do so. And I'm quite certain that counsel, as matters go on, will also assist. And he says, yeah. Further on that page, the learned deputy master at F says, I do appreciate that you are without legal representation, but I believe that with all the assistance that the bench can give and counsel can give, that your case will be given a fair hearing, Mr. Rea. So I will not grant your request for an adjournment, and we should proceed, bearing in mind, of course, that the matter had been before the learned deputy master, I think the week before, when an application by the appellants had been made to adjourn, and they had at that stage informed the court that they had dispensed with the services of their legal advisors. Can I just explain my position as trial counsel? Miss Rea had instructed a company called Absolute Barrister. And Absolute Barrister are now a company that has been dissolved. They were a company who members of the public could contact online. They would then effectively take instructions from that member of the public and allocate to them a barrister who would then deal with their case at trial or on any interlocutory hearings. That company would prepare the documentation. So when the papers arrived with me, I think as my Lord had mentioned earlier this morning, the difficulty was that when I read it, the respondent's case hadn't properly been put. I'm sorry that her statement that was before the learned Deputy Master isn't in the bundle.
I'm sorry, we got a bit lost.
Yeah.
Who instructed Absolute Barristers?
I'm so sorry.
Rita.
Miss Rita, yes.
Yes, I thought it.
So Rita contacted Absolute Barrister, explained the position that she had. They then effectively do the preparatory work, which included the preparation of statements. And then once that work is prepared,
yeah,
counsel are then contacted by Absolute Barrister to represent the client at court. And from memory, it was Absolute Barrister who prepared the trial bundle in this case. But the statement that Rita had filed, in my opinion, was unhelpful. It was deficient, hence why I asked the questions I did of Rita at trial.
Yeah,
and
you should have applied for permission.
My Lord, I accept that entirely. Can I immediately put my hands up and say it's probably the fact that my main practice is within the family court, when we are given slightly more leniency, and it's commonplace to ask additional questions once you have taken the client through the statements and deployed those. So yes, I don't try to hide behind that fact that I should have asked permission, and as my Lord has indicated, then obviously the court and the defendants would have known why I was seeking to ask those questions. What the reason that I did that was primarily to make sure.
So just to be clear, I mean, I think I followed from that I think actually Rita had produced 2 witness statements, not just one.
That may well be right.
She was asked to confirm the truth of them. But the real reason for you taking the course that you did in chief was actually because of the deficiencies of her statements.
Yes.
Not, in fact, as Mr. Justice Adam Johnson surmised, to assist the appellant.
No. And I can see, I think it's put by my learned friend that the appellant's thunder was stolen. That wasn't the intention. It wasn't done to assist. It was purely so that, in my mind, Rita's case was properly put before the court, and she answered those matters that had been alleged against her, which were absent from her statement, which in my view should have been in there.
Right, so they were absent from her statement.
Yes.
That's the question I asked Mr.
My
Howard.
Lord, yes, they were.
Yeah.
Hence the reason why I dealt with the matter in the way that I did, and as your Lordship sees, within my examination in chief of Rita, I dealt with matters sequentially in headings, which were effectively those allegations that had been made by the appellants.
But then it must follow that the first time the appellants would have heard those matters
Absolutely.
was in chief,
Yes.
and they wouldn't have had any chance to prepare
My Lord, that's absolutely right.
any questions or anything.
Yes.
Because it just wasn't there.
No. And as we read and we see in the transcript, they asked for 30 minutes. It wasn't allowed, and I think the learning master or a deputy master gave them 5 minutes. And that's a fact. I have I hope not oversimplistically, in my skeleton, dealt with the appellant's ground of appeal, and I really, you've heard a lot from a learned friend, and certainly as far as the law is concerned, I have very little to say, because the passages which he draws your lordship's attention are apposite to the matter that's before you in relation to fair trial. What I will say, again, in relation to the authority of S&P, again, it is commonplace now within the family court that, pursuant to Practice Direction 12J, that a litigant in person, particularly on a fact find where domestic violence is alleged, is required under Practice Direction 12J, and invariably directions are given, that the litigant in person sets out in writing those questions that he or she has of the other party, that they are submitted to the court. The judge will then look at those questions. Some courts list a ground rules hearing where the person who has provided a list of the questions is seen by a judge, so that the judge can go through those questions. Of course, the other side are not involved in that process. And so when at trial at a fact find, for example, the cross-examination takes place by the judge asking, for example, the other party the questions which that party has put in writing, and that party is always given the opportunity to come back with any further questions arising out of the answers that are given. And again, those questions are put in writing.
Sorry, can I just make sure I did understand what you just said
My Lord, yes.
to us? Because I don't have that familiarity. That you say that the litigant in person would be invited to put the questions that they want asked in writing.
Yes.
And there may be a ground rules hearing at which the judge goes through those questions with the litigant in person.
With the litigant in person.
But in the absence of the other party.
In the absence of the other party. And so the party who is going to be cross-examined by the litigant in person via the judge does not have forewarning of those questions.
Right, but there is an opportunity for the litigant in person to, as it were, make sure that the judge has understood
Yes. Yes.
why they want the questions asked, or
Yes.
the sequence, or whatever. So in other words, it's effectively briefing your judicial barrister, if I can put it that way.
Yes, and I think that the purpose of that is for the litigant to explain the relevance of the question that is proposed to be asked and what issue it actually goes to.
Yeah. You gave us the number of practice direction. I didn't note it down.
Practice Direction 12J
12J.
of the Family Procedural Rules 2010.
Yeah.
And I think it is still paragraph 28 where that procedure is directed.
And that's in fact set out. That was the paragraph 28. I was confused with.
My Lord, yes.
That was the one that was set out in.
Oh, that's in S&P.
That's the one that was set, that I thought might have been from Lady Hale, but it in fact.
No, my Lord, that is right. That's the one that is set out in S&P.
So it's at paragraphs.
It's on page 76, the authorities bundle, and it is paragraph 30, where Lord Dyson, the Master of the Rolls, is quoted.
Oh, I see.
And my Lord sees halfway down that, a third of the way down in Read W, children, was also recognised in FPR Practice Direction 12J, paragraph 28. And I checked this morning that still is the wording. Whilst ensuring that the allegations are properly put and responded to, the fact-finding hearing can be an inquisitorial or investigative process, which at times must protect the interests of all involved.
Sorry.
I'm so sorry, my Lord.
No, I mean, what that doesn't refer to is the ground rules hearing, which
No.
you say in practice takes place.
Can I say that the rules don't mandate a ground rules hearing, and that does vary court to court. Often there is no ground rules hearing. The judge receives the questions 7 days before the hearing, and then when the time comes for cross-examination to take place, he or she will go through those questions with the litigant in person. and you find some judges will allow all the questions, some judges will not allow certain questions, explaining why not. But the litigant in person, as I've indicated, at the conclusion of the judge asking the questions, is always allowed the right to come back and raise any further questions. I really cut to the chase, if I may, with no disrespect, and really picking up on what occurred at the conclusion of the solicitor and the doctor being interposed, and when we returned to Mr. Rea continuing his cross-examination of Rita. My Lord has helpfully identified that passage in the transcript where the learned deputy did indicate to Mr. Rea that he would have 2 hours or so after the short adjournment to continue his cross-examination of Rita, but of course that we know never came about because of the doctor and the solicitor giving evidence. And it clearly was a mistake that the learned master thought that question had been asked, or those questions had been asked earlier. What I say is this, quite simply, is that mistake is saved by what the learned master did, as has been highlighted by my lord, in that he said, and I'm finding the page,
She's recalled at page 142.
I'm so sorry, my lord.
She's recalled at page 142.
I'm very grateful. And it's at 148. Where we pick up at E, where Mr. Rea says we do not have any more questions for Rita at this stage.
Now, of course, before that, both at 144 and 145, the Master has said, I'm not going to allow questions on these matters that I think have been gone over before.
That's right.
So when Mr. Rea says, well, I don't have any more questions, that is in the context of the Master having said, well, you can't ask questions about these matters.
My lord, that is right. So the Master then says at F, so I'm going to ask a few questions which will help you do that, having told Mr. Rea that he's absolutely entitled to put his case, and indeed not entitled but bound to put his case to this witness. And then he asks a number of questions, and if I can just go through the questions that the Master asked, because in my submission they are clearly highly relevant. If we turn to 156, we see at 156 at D, the question is, your brothers say as part of their case that you gave your mother a false picture of your finances and told her that you were effectively hard up when you were not. Is there any truth in that? It's not true. We never talked about money and that kind of thing to each other. I never talked to my mum about how much money I was getting. It was something I didn't do with mum.
Now that obviously goes to a particular pleaded point.
Yes.
What's a bit tricky about it is that if you were certainly a barrister cross-examining, you wouldn't just leave it at that.
No. Now, on all the examples that I'm going to quote, my point is simple, and I do accept that Mr. Rea and his brothers were litigants in person, but they were there, they were making notes as the evidence was being given. They were given the opportunity to come back and challenge the answers that Rita had given. And we know that certainly, as I'll come back to those shortly, but if we come back to 158 under the heading at G, further cross-examination by Mr. Rea, we see that the questions are asked, and then at the bottom of 161, the master having said, I think I did ask the questions that can properly be put, Mr. Rea says, yeah, I don't think, have you got any questions like that? I think it's to his brothers. I think we're done with the questions. Thank you very much for your help. So there is, ironically, an acknowledgement by Mr. Rea there that the judge has been helpful. But if we go back to 157 and we look by the second hole punch at E, Master says, and your brothers also say that you were dishonest to your mother about how much care they were prepared to give. Is there any truth in that? There's no truth in that. Well, they say you told your mother they did not want to be involved in her care, and that was untrue. That's not true. When your mother said to the solicitor that she had been abandoned by her sons, you think that is how she genuinely felt. Asked to repeat. It was repeated. Yes, she did feel that, because there was a time I used to send David photographs of me and Mummy when he was abroad. And I used to keep regular updates with him that was like up. So I used to always send photographs and messages to them. My mum wanted them, you know, to be involved. Did she feel let down by her sons? I think so. Did you put the idea into her head? No. I didn't put any ideas into my mother's head. And then we see on that page at 158, the master says, now anyone who wants can ask questions arising from what I said.
Now there, the master has asked whether the mother felt abandoned,
Yeah.
and
Yes.
she got an answer. He got an answer, and said, well, did you put ideas into the mother's head? And there's an answer to that. But there's no development of the case.
No, and I have to accept that.
Yeah.
I have to accept that. And I don't want to appear rather unsympathetic. That it's one thing, of course, a counsel or a solicitor being told that they can ask any questions arising. It's a different prospect to a litigant in person. What I'm saying is, and I did say in my closing submissions to the master that these appellants had conducted themselves very well, and indeed one sees from the questions that Mr. Rea asked his sister that they were well asked. But all I can draw the court's attention to is that that opportunity was there, and I would say that that opportunity does reflect that the judge was being fair to the appellants.
You say, Mr. Ward-Prowse, that
Yes.
the opportunity was given to Mr. Rea to come back and challenge the answers that
Yes.
Rita had given to the master's questions.
Yes.
There are parts of the transcript where he doesn't allow that to happen. He says, well, the question's been put,
Yes.
it's been answered,
Yes.
that's that. For example, page 88. So, Mr. Ray is cross-examining about Dawn Strawn. And at B, the master says, that's too long a question, let me help. So then he says it's between C and D, according to something said to be in the transcript, Dawn Strawn says you blocked your mother from seeing her mother. Is there truth in that? No, there's no truth. Deputy Master, well, that's the answer to your question.
Yes. And I have to,
Now, it's true to say that Mr. Ray then goes on and says, I put it to you, you're lying.
Yes.
Dawn said otherwise. But there are, I think, other examples which I haven't got at my fingertips now, where the master says, right, I'll put an answered.
Yes, yes, and again, the transcript reflects that on time, on occasions, an answer's given, and the master wanted to leave it there.
Yeah.
And so when I go through that, and again I simply refer to my skeleton, what I say, quite simply, on behalf of the respondent, is that where we see in the supplemental bundle on page 60, which is the transcript of Mr. Justice Johnson's judgment.
60 of the core bundle.
Of the supplemental bundle, my lord. Sorry.
Ooh,
Is
sorry.
it core? I'm so
Core,
sorry.
sorry,
It's
yeah.
core. I'm so sorry. Yes, I'm great.
Yeah.
Page 60, yes. And I won't read it, but what I say,
So you're page 60.
page 60, my lord, at the very bottom,
Yeah, I see. Sorry.
paragraph 105.
Yeah.
What he says between 105 and 113, we say was something that was fair and which he was entitled to say on what he had read and what he had heard. And the conclusion that reached by Mr. Justice Johnson in the circumstances is not wrong.
I mean, he I think we've established he is actually wrong in the assumption he made at 105, the start of 105, as to the purpose of the extended examination in chief.
Yes, sorry, my lord. Yes, that
I mean, he goes on to say, whatever your motivation, the Deputy Master was right to know the questions have been asked and answered.
Yes.
I think the argument that is made is yes, but not by the right person.
Yes, I think that's probably a fair observation.
Yeah.
So, my lords, I don't know if there's anything further that I can assist you with. I'm sorry I've been brief, but I hopefully just get to the point.
Yeah. Okay, can I ask a couple of questions?
Please.
First is this: what is in the estate, apart from the house?
I think it is just the property. Would you excuse my back
Yeah.
1 moment? Property. What is the name? Yeah. What's the inheritance? Value of the property, which is the only asset, 750,000.
750,000.
Inheritance tax, 170,000. And interest, of course, is accruing on that unpaid tax.
Yeah. Second question is this: the question for Mr. Justice Adam Johnson was whether the Master had conducted an unfair trial, and that clearly is what's sometimes called a multifactorial assessment.
Yes.
And he, as a trial judge himself, came to the view that the Master had not conducted an unfair trial.
Yes.
What test should we be applying as an appeal court in deciding whether Mr. Justice Adam Johnson's overall assessment was wrong?
I think it's whether the judge, in taking into account what occurred at the trial, and in particular the way in which the appellant's case was put, whether in fact that was fair.
So we form our own independent view of whether we think that the Deputy Master conducted a fair trial.
No, I think you see the rationale and the reasoning of Mr. Justice Johnson to see whether the reasoning and conclusion he reached was on the facts fair.
Right.
I think there must be an element, of course, of your lordships looking at it and saying to yourselves, what you have seen, was it fair? Because, of course, I think that probably is the subjective approach.
Just following on from that, I mean, as I understand it, the question that Mr. Justice Adam Johnson had to answer was, was the hearing by the Deputy Master fair?
Yes.
It's not a discretionary question. It's a black-white question.
Yes.
It's either fair or it's not fair.
Yes.
So, do we gain anything by asking ourselves whether Mr. Justice Adam Johnson's view of whether the Deputy Master's
I'm sorry.
hearing was fair?
No.
Sorry.
Yeah. I see where you come from. I think you have to say to yourselves in looking at the transcript whether you form the view that that trial was fair.
Right. So if we simply disagree with Mr. Justice Adam Johnson, it doesn't matter that his view was a tenable view. We just disagree with it.
Yes.
Yeah.
Yes.
Right.
Yeah.
Is there anything further I can assist your lordships with?
Richard? If you want to ask him anything. Mr. Howard has submitted on basis of both NCB and Seraphim that if we come to the view that the Master did conduct an unfair trial, there is no alternative to a retrial.
I would concur with that.
You agree with that?
Yes. I think that must be right.
All right.
I'm very grateful, my lord.
Yes, Mr. Howard, do you wish to reply?
No, thank you. Unless there's anything I can... It's cropped up with you.
All right. Well, thank you all very much. We will reserve our decision. You will get a draft in the usual way. That will be your opportunity to correct obvious grammatical errors, but not to advance new arguments or to argue with our reasoning. We would hope, in the light of our draft judgments, you will be able to agree a form of order disposing of the appeal. But if that cannot be agreed between you, please make short submissions in writing on what you say is the appropriate form of order, and we will make the order that we consider to be the right one.
Thank you very much, my lord.
Thank you very much.
Count, please.